Hold up, wait a minute. Bruh. Did you hit the like button? Drop some rabbits in the chat. Let's go.
Hit that like, hit that like. Welcome to the chat, let's chit chat, hit chat. Hit that like, hit that like. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop some rabbits, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits. If you want the tea, come see me. Rabbit hole is the place to be for real news, not fake news. Celebrity news, breaking news around the clock. Real talk, best on the block. I rock, I rock, I rock, I rock. Real talk, best on the block. I rock, I rock. Hit that like, hit that like. Welcome to the chat, let's chit chat, let's chat. Hit that like, hit that like. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop some drop them, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits. True crime is my specialty, exposed in the industry. Unsolved mysteries, sticking to reality. Fair use commentary, talking about cults, trying to get results. Exploring hopes, exploring, researching, debunking, investigating, being nosy, super nosy, being messy, being shady. Rabbit hole news, that's me, the chick with ADHD, unmedicated but quite educated. Hit that like, hit that like. Welcome to the chat, let's chit chat, hit chat. Hit that like, hit that like. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop some rabbits, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat, drop some rabbits. Hit that like, hit that like. Let's go, let's go. Let's start the show, let's start the show, let's start the show, let's start the show, let's start the show.
Hi, everybody. Hi. Oh my gosh, you guys. They're having some arguments in the courtroom. Okay, y'all, please forgive me. It is my first day at work today. It is my first day at work. Can y'all hear me? Put a 1 in the chat.
On record in State versus Davis,
Please let me know if you can hear me,
C377407. For the
we
record,
got some
Mr.
stuff
Davis has
going
waived
on
his
right now in
appearance
the
for this hearing.
And I got to show you guys my screen.
Previously.
Let's just hope I don't break this.
What document are we working off of, Mr. DeJock?
Oh, shit.
The
How
one
did
I
miss this?
just sent
Hold
you.
up. I thought we were off today. I guess not.
We negotiated
1
some
sec, guys. I
language
got to
in
share
a
with you
bunch
guys
of
my
the
monitor.
instructions.
If I can figure it out.
The issue still before the courts.
Not that one.
I
Here we
sent-
go.
You got the defense instructions earlier.
Yes.
All right.
One, whether or not we give a voluntariness, and if we give a voluntariness to the statement, what voluntariness?
Can you guys
to
hear
the
it? Put a 1 in the chat. I'm going to fix my
Okay.
in a minute.
Two, we have a dispute over what corpus delicti rule instruction we give.
Of course.
The defense has withdrawn their 51069 request. The attacking the hearsay as if he testified to the client, as if he testified, they've withdrawn that.
Okay.
And then the defense does not want self-defense instructions, but the state believes we're entitled to them since Mr. Davis claims self-defense in at least one of his statements.
Good morning, Your Honor. Attorney Talene Pandak, bar number 5734, on behalf of the defense. I did print a copy of our initial defense proposed instructions. Would you like a printed copy for now?
I have an email copy. If you want those filed, go ahead and.
Well,
As
we are withdrawing one of the instructions.
Okay.
On page 9. On page 6, we're withdrawing the hearsay instruction. Pages 7, 8, and 9, the state has agreed to modify those and use our proposed exhibit.
Okay.
So you are here to determine if the defendant is guilty or not guilty based on the evidence in this case as opposed to guilt or innocence.
Okay.
And then the state also changed the one about the subject of punishment to not say guilt or innocence, but to talk about the burden of proof. The state has also agreed to give the instruction on page 9 of our proposed instructions on the constitutional right of a defendant not to testify.
All right. So then what I think makes the most sense, tell me if I'm wrong, is just to go through individually. When there's no objection, just number that, move on to the next one, and organically raise the issues as they come up with the instructions. If there's something that doesn't get raised, ultimately by the end, then I'll circle back and ask about the defense proposed.
I would agree with that, except for I don't think you want a number, if you do wind up giving the voluntariness, I don't think you want a number them after the last instruction. So
you want to start with
maybe we should address
voluntariness?
whether or not we should be giving voluntariness, and then when we get to the area where you want to argue voluntariness.
All right, let's go voluntariness of statement as our first issue. Let me pull up the instruction that you have proposed. Defense. And then state has presented an alternate.
An alternate, but also an argument that there is no voluntariness that gets submitted to the jury.
Okay. So, is the instruction that you are proposing to give the one from Vasquez-Reyes versus State and Colorado versus Connolly misconduct?
Oh, I am.
That's the one that the state is proposing.
My proposed is from Carlson versus State, 84 Nevada 534.
If you actually just want to approach with yours, at this point, I don't know. It doesn't look like I received your entire packet, so everything. So I can just go through it, print it. Thank you. All right. So the instruction that the defense is proposing three different instructions, correct?
I have three different options. The first one is directly from Carlson versus State. The second two are from instructions that I used as a district attorney.
All right. So what's your preferred one that I start with?
I'm happy with all three of them.
Okay, so you'll take any of the first three. So
Well,
either.
and definitely the second one on page 3 talks about the difference between an admission or a confession, so that one's different from the page 4 one, which talks about the totality of the circumstances and the voluntariness.
State, what's your objection regarding a voluntariness instruction being given at all?
In both the cases cited by the defense, I recognize, both of them say where voluntariness of a statement is an issue, that you have to submit it to the jury. The mere fact that they filed a motion to suppress on voluntariness doesn't create an issue. They have presented, you have to, as Connolly says and Vasquez-Diaz says, you have to establish some improper police coercion, and they have not done that in this case. The audio of the statements do not reflect any improper police coercion. Both of those, neither one of those, have you found to be to be custodial, and so in both these cases, they're Mirandized statements of defendants who are in custody. There is a lot of law that, right, if there's evidence of self-defense, you got to give self-defense. If there's evidence of a voluntariness, you have to give a voluntariness, voluntary manslaughter. There is zero evidence before this jury that they could factually make any sort of determination as to the voluntariness of the defendant's statements. By its very definition, a proffer cannot be involuntary because it is a negotiated contract between two people. So the only statement this could apply to would be the 2009 statement. And when you listen to the 2009 statement, it's clear there's not a single improper coercive conduct by Detective Long. Now, had the defendant got on the stand and said, hey, they beat me with rubber hoses before I went in the room, or hey, the cops told me this, or the cops told me that, or the cops told me this. The evidence before this jury is he was caught with PCP and a gallon of PCP and a kilo of cocaine. They told me I could be prosecuted for that, or I could give a statement. I negotiated a contract with my lawyer, with the government, to go in and give them a statement. By its very definition, it cannot be involuntary. And so If you instruct the jury on this, particularly the instructions they're requesting, it would be highly, highly confusing to the jury, and it's not an issue in the trial, because they brought zero evidence of coercion, improper police coercion, into this case. And because of that, I would say they're not entitled to a voluntariness instruction.
In reviewing the instructions that are offered,
Can I approach to give you the two cases, Carlson and Morrison?
you may. My initial concern in reviewing what you stated before I even get to the threshold matter of whether you've met, well, first I have to decide the threshold matter, but if we were to give an instruction, all instructions say that ultimately if a jury concludes that a confession or admission was not made voluntarily, then it's up to the jury to determine whether they should consider it. However, none of the three instructions give any insight to the jury as to how they would determine voluntariness. As a judge, when there's this motion to suppress brought up before me, in general I have factors to consider. The jury would have none of those in the proposed instructions, and so it would be giving them a task that they have no way of accomplishing, essentially, is what is in front of me.
And what the defense is submitting in the Carlson case, they had an instruction that the Nevada Supreme Court ruled was sufficient in that case, and that is in the state's first proposed exhibit. And they actually gave the footnoted instruction of the fact that the court has admitted into evidence the alleged confession or admission of the defendant does not bind the jury to accept the court's conclusion, and the jury, before it may take the confession or admission into consideration, must for itself find whether or not it was voluntary confession or admission. If the jury concludes that a confession or admission was not made voluntarily, it is the duty of the jury to entirely disregard the same and not consider it for any purpose. That is directly from the Carlson case.
They're saying voluntary carries a clear meaning without need for further definition or explanation.
That was going to be my very next argument, Your Honor. And they did say that it was error if the court did not give that instruction. And what they talked about was, and this is going to be something that's a theme running through all of our objections, there is a difference between admissibility and the question of fact that the jury now needs to decide. So here, Mr. Giacomo is absolutely correct that you have the initial determination of admissibility. You have ruled that it was voluntary. This will be an issue on appeal. This will be something that will be brought up by the defense should Mr. Davis get convicted. However, you also then are required by the Nevada Supreme Court to instruct the jury based upon their role now, which is determining whether or not there is evidence beyond a reasonable doubt. To me, that is how I read these Nevada Supreme Court cases, that you need to give these instructions. I do see the court and Mr. DiGiacomo's concerns. It is the defense position that we would rather have all of the instructions given as opposed to just the state's. So I think it's better to instruct the jury than to not about all of the applicable rules. But I do think, and this will become even more important in the next argument about corpus delicti, I think that we do not need to instruct the jury on questions of admissibility. I do not want them to be confused about the proper standard that they need to decide, which is proof beyond a reasonable doubt. At this stage, it's a question of fact for the jury.
So let's work backwards then. Where in this record do we have evidence of improper police coercion, where we don't have, we have a statement that was given in the presence of police, or in the presence of his attorney that he brought there. We don't have any of the typical PASAMA factors present of, you know, someone who's very young, someone who's very hungry, someone who's very tired, someone who's very susceptible to police coercion because of their lack of familiarity with the criminal justice system. We have none of those factors present here. Additionally, we have a defendant. But hang on a minute. And we also have someone who has not testified to explain a circumstance outside of those. Outside of what is actually within the videos, and then ultimately no evidence that well, apparently it would be difficult to know what to apply to this situation, but what is the, I guess, improper police coercion here?
Well, the defense, we all should not be arguing this right now. It's a question of fact for the jury. I'm not going to restate the evidence that we already heard at the trial, because it's up to the jury to decide.
You need to make a prima facie case.
Exactly, but it is our position that those factors, whether they've been met or not, would be up to the jury to determine. Both sides are going to have arguments and closing arguments that are going to be very different. This is one of the biggest issues in this case, and I think it's important to continue on to allow these instructions to be given as decided by the Supreme Court. I think it would be error not to give the instructions, and I think that there is some evidence of psychological pressure. That is going to be something that the defense may argue in this case based on the testimony at trial, but I don't think it's appropriate for us because it's a question of fact for the jury.
But we need to get at least that there's something in the record to show, you know, like if we're talking about voluntary manslaughter, you have to have at least that scintilla of evidence to get over that very small molehill. What evidence is there to give these voluntariness instructions at all to get that first hurdle that Mr. DiGiacomo is, I guess, complaining about?
And I know that this court disagreed with the defense when it filed its motion to suppress the statements, but the defense detailed at length what the promises were. There were explicit promises made to the defendant in the 2008 proffer. There were implicit promises not to use it against him in the second 2009 interview, and those promises, while contested by the state and contested by the court, there was evidence of promises made to the defendant. There was evidence about confidentiality that they agreed to keep. There was evidence about when that confidentiality was broken, who broke it first. These are all issues that are going to come up during closing arguments, and I'm sure they're going to be issues that are going to be deliberated by this jury in making a decision.
But none of that goes to voluntariness. Somebody violating something 5 years or 3 years afterwards doesn't change the voluntary nature of the statement. The person or the entities that contracted have never violated the agreement that was contracted. The contract was between Mr. Higgins and the U.S. government. The U.S. government never violated the contract. The suggestion that as a matter of law, you can never have an involuntary proffer. There would have to be some additional information that is elicited. The fact that they don't like what Mr. Kading did does not somehow change the nature of what happened 3 years before. And so the psychological pressures that they're talking about are exactly what U.S. Colorado v. Connolly say are not appropriate for purposes of the Sixth Amendment involuntariness. That is clearly not a situation where they're allowed to argue to a jury that because him and his family were wrapped up in a drug deal, that he somehow has the right to claim that his statements are involuntary. The Sixth Amendment is there to protect against improper police conduct. It is not there for this purpose. So when they use the term voluntary, he didn't have a choice. Well, he did have a choice. He could go to prison for the rest of his life on drugs. But he chose to make a statement to the police. And so there is no evidence of anything improper police conduct that has occurred here.
May I add something, Your Honor?
You may.
I wanted to clarify that the burden of proof is on the state to prove by a preponderance of the evidence that the confessions were voluntary. That is a burden of proof at the time of trial, not at the time of the motions. So in this case, they do have that burden to prove that beyond a preponderance of the evidence. So I think that's also relevant, and I think it's important in this case that we give this question to the jury based on the Supreme Court law that's in place. But as Your Honor well knows from all of the briefing in this case, There is very little law specifically on point to this issue. This is a unique issue. This is something that could create new law in the state of Nevada because there's very little law in Nevada that even remotely talks about the situation that we have in this case. And I think that it's very important to protect the record that the instructions are given. And I'll submit it to Your Honor.
Okay. I think it's safest to give some sort of voluntariness instruction to this jury, given the precedent in the Nevada Supreme Court, given the Carlson versus State case. I definitely agree with a lot of the state's arguments, and that's why I ruled the way that I did initially. However, it's clear that this has been an issue that has been raised by defense. It's something that they disagree with my ruling with pretty strenuously. And in the record, there is, that statement by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets. So, that being said,
And I'd ask you
let's
to look
talk about the various instructions then and how we're going to do this.
I would ask the court, and I will tell the court that, I cannot believe I'm actually going to say this, but I pulled those instructions on voluntariness from the Nevada pattern jury instructions. The only thing I did was conform slightly to this case and added the Colorado v. Connolly portion that says self-interest or an expectation of receiving a benefit does not make a statement involuntary. That isn't actually in the pattern instructions, but clearly it's the law, and that's why I sent you Vasquez-Reyes, because Nevada has adopted Colorado v. Connolly. And so the instructions I gave you on voluntariness, and I'm trying to pull them up here because I didn't have them up on my computer initially here.
And so these are, your instruction is the pattern?
Is the pattern with the exception of the last line on the first page,
Okay.
I believe.
And so, Ms. Honda, the instructions that you've given me, obviously the one on page 2 involves Carlson and Lorson.
Yes.
Those are Nevada Supreme Court cases. The other two sites are simply for the stock CCDA brief bank instruction. Do you know where those necessarily come from, and if they were not incorporated into ultimately kind of the pattern? The idea was to incorporate those stocks into the patterns.
Those have been instructions that have historically been used by the district attorney's office that have been upheld by the Supreme Court. So those have not been challenged. Those haven't been, there have been no problems associated with those instructions. That was initially what I had asked the state to include that precipitated all of this.
Okay.
So I wanted to make sure that the court had those instructions. I agree with the state that their instructions are a correct statement of part of the law that applies. I'm not saying it's complete in terms of all the issues in this case, but as to the PASAMA factors, those are the factors, and I do agree that they're correct statements of the law. So we do not object to the admission of all the instructions, both the state's proposed as well as the defense proposed.
Well, the second two DA brief bank, I'll be honest with you, and then, she was at appellate for a long time. Those are no longer in our stock instructions. These pattern instructions of what we've put into our stock instructions, because those are clearly, as the court noted, not adequate to explain to the jury voluntariness in a legal sense what that is. And so if you're going to give the instructions, I would urge you to give the Nevada pattern instructions with the Connolly addition to them. But not, well, I mean, I think it's superfluous to even have the what is it, the Carlson-Larson one, because these two instructions fully explain, hey, there's a confession and an admission, here's what the difference between the two are, here are the factors to consider in determining voluntariness, there needs to be improper police coercion involved in them.
I don't believe those two are sufficient. And I think that under Carlson, them saying that the term voluntary contains a clear meaning without need for further definition or explanation, that's also a clear mandate by the Supreme Court. But I would ask at a minimum.
Mandate from 1968.
Right. But there's been nothing.
In which the defense was actually asking to give the factors to the jury, and the court said it was sufficient in 1968. But this is a very specific voluntary issue, right?
Okay. Turning back to Ms. Panda, when I look at the instruction the state is offering, it does seem to incorporate what you've included for 3. It talks about what an admission is, what a confession is, and what the definitions are. It seems to be very similar language, and I think it was probably what was used to make the stock pattern, the stock instructions that the Supreme Court is encouraging us to use.
Yes.
And so it seems to be the predecessor to that. Would you agree with that?
Yes, it is fine to use both of those instructions.
Well, I'm just saying, I don't know that we need instruction 3 if that one is being given.
That's fine, Your Honor.
Okay?
I just want to make a complete record.
No, I understand. I'm just, if you agree with me that it's already incorporated in the instruction, I'm not going to give duplicates. So
Exactly.
3 doesn't seem to make sense. Page 3 doesn't seem to make sense. Page 4, let me compare that. I think page 4 does include additional factors, which include that the state has the burden of proving voluntariness by preponderance, but then it goes into the voluntariness being a question of fact to be determined by the and what you're to do if it is determined to be involuntary.
And I would ask that that instruction be given.
So I think 4 is incorporating your instruction 2. It has all the same features. So my thought is to give the state's instruction as well as page 4. And I'll let Mr. DiGiacomo be heard on that, just because it will avoid duplication of the exact same issues that could confuse the jury. Additionally, it includes an explanation to the jury of what to do to determine if it's when you determine it's voluntary or involuntary and who has the burden.
Okay, so you're going to give both of the states, and then you're going to add 4?
Oh, the state has a second?
Yeah, the second.
I haven't gotten to the second.
Yeah, the second one actually has all the factors listed out, and it does cover everything that's in her number 4.
Okay. Let me look at that one. I apologize.
Page 2 of ours, the passive factors.
The state, and it includes that the state has the burden of proving, which I indicated earlier was a very important part of instruction 4. I think ultimately in comparing page 2, it does encompass all the ideas of page 4.
So instruction number 2 will not be given on page 2.
Right. I think what she's saying is she's going to take R2, it encompasses all 3 of yours. Is that what you're saying?
No, she's going to give on page 4.
Well, I didn't realize there was a page 2 to the state. What does the state's proposed either omit? I see that it adds the PASAMA factors, and you guys don't want the PASAMA factors given. Is that sort of the difference there?
I already said it was fine to give all 5 instructions, so I'm not saying that their proposed instructions are an inaccurate statement of the law.
Got it. Understood. So at this point, I'm going to give voluntariness instructions over the state's objection. However, I'm going to use the two that the state has proposed because they are pattern instructions, which we're encouraged to use. Additionally, in reviewing them and comparing them to the ones that were sent over by the state or by the defense, they do include all of the factors, as well as the fact that the state has the burden of proving the voluntariness by preponderance of the evidence. So I think they encompass everything that is necessary. They encompass the defenses, and to avoid confusion, I'm not going to give all five. I'm just going to give the two that include the same ideas.
What about the one on page 4? You had said earlier you were going to give that one.
And I think that was before I knew that the state had given me even a second page.
Oh, okay.
So I was just looking at page
Okay.
1. I apologize. So now that I've got that. All right. So the voluntariness instructions will be given as proposed by the state. But to be clear, the state does not want voluntariness instructions. The other issue that we needed to address was corpus delicti. The defense is proposing on page 5.
And to be clear, Your Honor, the defense objects to the corpus delicti instruction proposed by the state. The only reason that we provided an alternative proposed instruction is because they included it in their packet. The defense objects to any corpus delicti instruction being given to this jury at all for these reasons. While the first attorney in this case had potentially raised a corpus delicti issue in his motion to dismiss, this defense team has not raised corpus delicti either in a motion or in front of this jury. That issue has not come up. It is a question of admissibility, not a question as to weight, and the defense objects to this instruction being given because we believe that it is confusing and misleading to the jury because their duty is beyond a reasonable doubt, and their duty is as to weight, and it's confusing to even have this instruction. However, if the court disagrees with the defense position and will give an instruction, the case provided by the state, Sefton, that's actually from 1956, and the proper standard is the Doyle case. In the Doyle case, they provided, this is the exact instruction that comes out of Doyle, which is Doyle versus State, 112 Nevada 879 from 1996, Nevada Supreme Court, and that instruction is a more accurate statement of the law.
Your Honor, may I be heard?
Which one is your corpus instruction?
That is on page 5.
No, sorry, state. I'm on yours.
Okay.
It's near the end.
Give me the first couple words once you find it so I can...
Where independent evidence.
Where independent evidence. Okay, then I can control that then.
It's about 42 of 53. Although I may have I just added in the voluntary instructions, so maybe not.
So the instruction the state is proffering reads, where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I don't know that that's necessarily a corpus issue.
It is, Your Honor. So this is what, and I'm going to disagree with Ms. Panduck with regards to the defendant's the never taking the position that about the corpus delicti issue. What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says And what even Ms. Panduk's case says, and I'll get to why that's not applicable here, but what even Ms. Panduk's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up.
Yeah.
You're kind of inverting it.
No, so at Sefton, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's 1, death, 2, by criminal agency, 3, what the defense had proposed, and what Mr. Sanft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Sanft said. I mean, it's a direct quote from his opening statement. But that's not the state of the law. And when Mr. Sanft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so, the question for this court is Mr. Sanft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Sanft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that we don't, that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is, regarding confessions, is that we do not have to corroborate anything beyond person being killed and the criminal agency. And so Ms. Panduk, again, in Doyle v. State, the thing that she pulls is from a kidnapping case, or from a kidnapping charge. But in another case that Ms. Panduk cites, West v. State, gives a very similar understanding of
You actually cite West v. State, too.
Yes, well, she cited it, we cited it, we both cited it.
Yeah.
And the one thing that we can agree is the two parts of corpus delicti, the only thing that we have to independently establish is the death and by criminal agency. That's the only thing we have to establish. We don't have to corroborate anything else. And so the only question is the jury going to have to be, is the jury going to be misled about whether we have to corroborate or not? And what the instructions are there to do is to have them not misled as to what our burden is.
May the defense respond?
1 second, I'm not quite through with understanding the state's argument. Sefton states that you need, for a homicide, you need proof of corpus delicti, which we've always had in this case, right? No one ever...
Never challenged that.
Well,
Not during the trial.
there have been challenges to which, in the media as to whether Mr. Shakur is alive or dead, but in general, we've always had the fact that Mr. Shakur died that day, and the body of the crime has always existed. And so corpus delicti wasn't really the issue here. It was the defendant's corroborating confession. Is that enough? And so...
Okay, so we can...
So I think that's...
So if you want to get rid of the first sentence where independent evidence established that the victim's death was caused by criminal agency and other, that's fine. But a defendant's own statements admitting the crime need not be further corroborated as an accurate statement of law. And if I may read from Section B State, It does say, a conviction based on confession will stand, although it is uncorroborated otherwise by proof of corpus delicti. So what Sefton specifically says is, we do not need to corroborate a defendant's statement. What Mr. Sanft told the jury is we need to corroborate a defendant's statement. So the question before this court is simply whether the jury gets the accurate state of the law or they do not.
You may respond.
She's so over them,
What
guys.
the state argues is actually incorrect. The issue is regarding admissibility. So this instruction is only relevant for admissibility. If there was no corpus delicti, then none of the defendant's confessions could even be admitted at all. You would have been precluded from admitting them to even let the jury hear about them. What the defense's concern is now is that this is improperly impeding upon their duty to find guilt beyond a reasonable doubt. This is infringing upon that standard. There is absolutely no law that talks about the fact that you do not have to corroborate a defendant's confession in terms of a jury verdict with beyond a reasonable doubt as a standard. And I would like to use the example, there is one situation, that is the Gaxiola case, and the Gaxiola case, I believe, oh, here it is, I have the site. 121 Nevada 638 from 2005. The testimony of a victim of sexual assault does not need to be corroborated, and that is entirely different than the situation in this case. The confessions were admitted into evidence. That was correct. They absolutely can be admitted into evidence, but this instruction improperly instructs the jury that there's arguments by the state, arguments by the defense, that they get to consider. They get to consider all of the evidence, and we cannot interfere with the burden of proof. So the state is wrong.
So, Your Honor, if I may be heard, like, Sefton is not about admissibility. Sefton doesn't say this is about admissibility. It is about the threshold of proof, which is here. Now, if the court wants to add, it's still up to the jury to determine what weight to give to a statement. That's fine. But in terms of, like, the inaccurate statement of law being offered,
Where in Sefton does it say a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime?
okay, it's if you do a Control F cert, F5 if you want it, if you're there.
Sure.
It says use conviction based on a confession will stand, although it is uncorroborated otherwise than by proof of the corpus delicti.
It doesn't cite to any other cases.
Actually, it does. In footnote 41, it goes on to say, it says, to this text, many authorities in support of this rule, and where corroborated evidence has been adduced, the rule is further stated. The corroborating evidence need not be such as to connect the accused with the crime. And then it goes on to say, hundreds of cases supports this rule and are cited in this note.
I believe Doyle supersedes that.
All right, let's look at Doyle.
And again, Doyle is
a kidnapping case.
Doyle is, they're talking about specifically a kidnapping case. Or a kidnapping charge. It's a murder case, but a kidnapping charge is where the corpus comes in.
I don't think that matters.
The West case that you guys both agree on, let's talk about that maybe.
Okay.
So that is clearly, that's a no-body homicide, correct? Brookie West, right? That's
Yes,
what
there
you're
was
saying?
no body in that
Okay.
case.
So obviously a very different situation.
Yeah, that's just the two precedent factors that the state has to independently prove, which is the fact of death and the death occurred by the agency of another.
And I don't want to jump in, but she mentioned Gaxiola. Why would we be entitled to instruct a jury that a victim's sex assault cannot be corroborated, but we can't instruct that in a defendant's statement? Gaxiola supports the argument.
And this isn't an attempt to change the burden. If the court wants to add to this that, you know, the state still needs to prove the case beyond a reasonable doubt, or it's up to the jury to weigh, give what weight it wants to give to the statements, that's fine too. But it is axiomatic that we do not have to corroborate a confession. And the law supports that position, and Mr. Sant has told the jury different, which is not true.
Only the proof of corpus.
Y'all hear me, right? Everybody hears me on the mic? Put a one in the chat. Just want to.
So really the argument here boils down to whether
Okay.
the defendant's statements need to be corroborated by any evidence, or in the case of the Ms. Panduck is stating it needs to be slight or prima facie for the kidnapping.
Well, that is regarding whether the crime occurred. That's not even about whether or not his the statement. I mean that the what.
Right. Okay. Because when in the kidnapping context, there's a situation where that crime could have not occurred.
Right.
There could have been no kidnapping whatsoever. It could have been a complete fallacy, a complete made-up situation. Whereas when we're talking about a homicide, there is proof of corpus automatic within the body existing.
Correct.
Okay.
Doyle is just not used in kidnapping cases. That's the standard that's been used since it came out. Everyone cites to Doyle. Doyle is the standard for the corpus delicti rule.
Not according to West, which says the corpus delicti rule in Nevada is well established. To prove that a murder has been committed, the state must demonstrate the fact of death and the death occurred in a criminal agency of another. So that's what we got to establish. And then, independently. And then the only question is, do we have to corroborate anything else or not? And the law is clear. We don't have to corroborate anything else. Now, of course, Ms. Panduck does have a fair point. They're not required to accept it. But we're also not required to corroborate it. And that's the impression that the jury was given by Mr. Sanford when he said, you are required to corroborate it. We know that's not the law.
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes. If believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply and
You
should not be
just
given.
stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So the corpus is beyond approved, right?
Correct.
So
We didn't raise
Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body. Always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial. You
Corroboration.
admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
you might want to just listen for a second, Mr. Paul. Okay, so the state's instruction, I believe, is in reading through and reconciling it with Septon versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the states?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but where independent evidence establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed exhibit, the defense proposed instruction?
So, well, the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduck?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given, because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given. There need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confessions or admission. To me, is less clear than defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I think our language is far clearer for the jury, and I think this is more duplicative than anything else.
I also believe that there should be a reasonable doubt admonition then as well placed in here. I believe this is still confusing to the jury, and the defense should be able to do the arguments as they intended.
What's the proposal to add a reasonable doubt instruction into this instruction? Or is that something that you
I would ask
could be fixed by putting it close to the reasonable? Well, what are you asking?
No, I would ask that in this instruction, right after here, that it is up to the jury to determine the weight to be given to the confessions or admissions, and they must determine beyond a reasonable doubt,
I don't have a
but
problem.
definitely weight.
Yes,
It is up to the jury to determine the weight to be given any statement or any confession or admission.
I think that's a fair statement of the law, and so I don't have any objection to that.
All right, so that instruction will read as follows. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given to any confession or admission.
That's not the statement.
Okay. Obviously over objection, but incorporating some of the defenses, that is how that suggestions, that is how that will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents, and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Shaft has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense, right? It's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that, but the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Shams, but defendant himself, in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, well, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Shamp argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least 2 statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to pop him or something like that?
No, at one point he says...
I'm confusing it with a different statement.
At one point he says, and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here because...
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
First of all, I would note that if the state brings these instructions in, they're adding to their burden of proof at trial, because they have then the burden of proving that the defendant did not act in self-defense. So I don't know why the state would want to add to their burden if the defense is not even requested.
Leave that on them. You don't have to worry about that anymore.
That I don't understand.
Okay.
We're not asking for those instructions because we're not going to be arguing self-defense. We believe it would be confusing to the jury. It certainly is an accurate statement of the law under Runyon, but also under Runyon, it's up to the defense to ask for those instructions. I don't know of there being any case where the state can ask for them when the defense has not, but in the end, the defense will submit that to your honor.
Okay. Final word, State?
Yeah, it's in 2017 where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says it.
Well, he uses the word self-defense, but I mean the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense? And the defendant says, yeah.
Ms. Pandak brought up a good point. I don't know why you'd want to take on a burden of disproving something that they're not even raising, but...
Well, that's on me though, right?
Yeah. All right, I'll give you the Runyon instructions. So we've gone through voluntariness of statement. That was granted. We're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given. Over defense objection, and the self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you. All right.
Also, for the record, I don't know if I made this record earlier, but there were wordings in the state's proposed instruction that I suggested making some additions, and the state granted that, and they made all the additions that I requested to other instructions, so I don't think we need to make a record as to those specific...
Except for she doesn't have those in front of her. I have been taking down notes of everything you said. I now have a clean copy with our instructions in order as it relates to the voluntariness. How about I say we send them to the court and we use those?
Oh, we do that in every other case. How come I have to do it in every other case? Anyway, okay, just kidding. All right, so at this point, I'm gonna have you email all the parties with the notes that you've taken. We'll review them, and then we'll go through one by one, making sure there are no further objections. While you're doing that, any way you can make page 3?
I can't. I mean, maybe.
Yes, to
maybe
not let
Anne
it
can get page 3 to get that word off. I couldn't figure out how to
Question
get.
on that. Determine whether or not the defendant is guilty of one or more of the offenses charged.
Guilty, I guess.
Of the offense charged? 'Cause
Of
there's
the
only one
offense.
charge.
Yeah. Well, that'll solve it.
Okay.
Or just don't make it an extra.
Of the offense charged.
Or make it smaller.
Guilty of one or more of the.
Okay, if you do guilty of the offense charged, it actually fixes the issue.
It does.
Okay. So.
Let me
that was
save
just us
this as
being
the final.
Style wonks. All right. Send it over.
That's charged, okay.
Yeah. Before I make sure I did put those Passimo ones in here. And their self-defense. Come on.
So, the one that you sent me at 9:13 a.m.
Didn't have the self-defense ones in them. Or not the, it didn't have the Passimo ones in it in place.
Okay.
So that's why I added those. Proffer statement. Statement made during police interview. Okay, yeah, they're in here. Okay, this is ready to go. I'm emailing it now.
Thank you. Do you have the Bolton instruction in there somewhere?
There is
On conspiracy.
multiple versions of Bolden in there. Do you want to send it? Do you want me to send it to Anne too?
No, I'm going to print it out myself.
Okay.
And you're getting rid of the sites on the Sefton and West piece for everything?
Oh, did you have sites on there? Hold on a second before I do this then. Oops,
Is there a playback in here too somewhere?
there is.
Okay.
Okay, I think it's good now. Let's see. Instructions. Insert. Okay, I think these are all right. People check. Mike, I didn't send it to you. I sent it to Megan. I sent it to Colleen and Megan.
How dare you?
Because I know you don't even know how to open it right now.
Well, I have it open, just waiting for it right now.
Oh, well, you want to report it to you right now?
No, I want to read it.
That whole law thing gets in the way of what you do.
Words.
So then just do a final run through. I'll let you read through and make sure that that's what you've agreed to, or what you've all either made a record on, and I've ultimately made a determination of. Ms. Panduct, okay?
Okay.
And then I'll number it if that accurately reflects what we've done here. Okay, so it is now my duty as judge. Any objection?
Judge, they don't have a copy.
Oh.
So, I mean, I emailed it to them, but they don't have a computer.
No.
Oh,
So can we print a couple of copies? We'll just do it manually.
That would be great.
sorry, trees. Okay, did you email it to you?
It's
Okay,
totally
I'll fold
Colleen.
it.
Still non-green.
It is me. I'm very old school.
I'm just gonna go print in there. It's fine. I'll be back. Thank you. You're welcome.
I'll give you a new copy of our version.
I have no idea what alert is making
This
that.
is only the second trial where the voluntariness of the defendant's confession has.
I gotta figure it out at some point.
125 trials in, only one other time have I had somebody ask for it.
I've always asked.
And in
I've
that
always
case,
included it.
the defendant did get on the stand and say they beat me with rubber hoses.
I've always included it.
Thank you guys for the makeup brushes and the flowers and the jewels and the thank you, the First Lady 69 for the flowers. We waiting, guys. It's all his family. Wow. It's the jewels, says Rachel. Raquel, I gotta figure it out. Well, y'all made somebody mad who was sending me, thank you, Dee Dee, who was sending me jewels, because it's like, they're like, can you turn off the alerts? I just did. It's another box. I don't know. It's the gifts? What? Damn. They also need a mute button too. I don't see them. I mean, I see them, but I don't see them. Okay, gotcha. It's not all the jewels. Yeah, some of them get bypassed apparently. She went to go to the potty break. Y'all hear me, right? Gold coins makes the sound. Okay, thank you, Sassy Crass. I wish maybe I could do it here. Hold up. That way I can know who's gifting, who's doing jewels. Because the jewels go by so quickly, it's so hard for me to keep up with them. Thank you, guys. If you've been giving jewels, thank you. And coins. Thank you, guys. Appreciate it. You hear me. Good. I'm glad. It's so perfect. So this is my first day using Streamlabs like completely for more than, how long have we been? For more than an hour. Wow. I still got to get used to it. You said you'll be taking serious subjects and wearing crazy. Look at this. I thought all right, we're going to have to figure it. Some of them clearly bypass. Vicky, you hear them on all of them? All the jewels? I muted the alerts, so it's not my alerts. You said, just wait. In no time, you'll be talking about a serious subject and wearing crazy hats and faces. Who's TT? I don't know who that is. Wearing crazy hats? Girl, I already wear a Nancy Grace wig. I don't even know where it's at right now. That thing needs a perm. Oh, I sent you emojis that were requested to your Discord when you have the time. Oh, okay, cool. Hey, Ty. Yes, I'm able to do a panel. I figured out the collab part. So we're going to do that after this so we can review it. So even though I muted the alerts, y'all still hear the alerts. Okay, I'm sorry. I promise you guys, it's not my fault. I have it on mute. 4 years ago, I told people I was going to learn how to use TikTok. Like, okay, gotcha. I was like, the hats. I'm like, what are you talking about, girl? We need two of you. Oh yeah, Trisha, we're gonna be the trial does not start for D4VD. It's just a hearing. It's not the trial yet. We don't know the trial date yet. We don't have a trial yet. But I'm gonna split. We're gonna do something on Monday. We're gonna have. Luckily, they're about an hour apart. Closing arguments for Tupac in that hearing. So we're gonna do one live stream to cover both topics. So we'll be there. I've already contacted some folks in that area in LA that are going to be there too. So we'll figure it out. Does it alert when you clear them? It doesn't even let me clear them. I got to figure it out, y'all. Honestly. How many people do we have in this live chat? Shout out to everybody, guys. Shout out to everybody. Make sure you guys are hitting the like button. Shout out to the 324 people, guys. Can you guys get us to 100? Get us to 200 likes, please. And thank you. It's just a conversation. You know how I've been dropping the link. I kind of want to learn how to drop the link for Streamlabs too. So we gonna do that. It's a conversation. I think you're doing great. Thank you so much, Alexa. Appreciate it. No. We got to figure that out. I have to figure out why some alerts get bypassed. Here we go. Let me shut my mouth.
Thank you. Okay. Thank you. Does anyone need clips?
I would.
I didn't bring it back. Oh, I said it.
Give one to me. Okay.
Well, if it's good, we gotta find a pen. We didn't plan on selling trees today.
One of you brought no pens, one of you brought no computer. There's something here, but all right. I'm too tired to make the connection. Okay, let's go through then one by one and see if there's an objection. I will number them as we go, and then you will have a complete set, I think.
Thank you.
Okay. It is now my duty as judge. Any objection?
No.
No.
That would be one. If in these instructions any rule, direction, or idea is repeated,
No objection.
that will be given as 2. An indictment is but a formal method of accusing.
No objection.
No objection.
That will be given as 3. A conspiracy is an agreement.
No objection.
No objection.
That will be given as 4. It is not necessary in proving a conspiracy.
No objection.
That will be given as 5. Each member of a criminal conspiracy is liable.
No objection.
That will be given as 6. If one member of a conspiracy withdraws,
No objection.
that will be 7. Evidence that a person is in the company,
No objection.
that will be given as 8. When 2 or more persons are accused of committing a crime together,
No objection.
that will be given as 9. Murder in the first degree,
No objection.
I think that should be is a specific offense crime.
Yes.
That's correct. It should be.
Okay.
Is a
Specific offense crime. Not, yeah. No S on crimes.
yes.
Murder in the second degree may be a general intent crime. Okay.
And that is number.
Actually, murder in the first degree shouldn't it be specific intent crime?
Yes.
Yes. Specific intent, not specific offense.
That's yes.
Specific intent crime.
Yes.
And you're gonna clean these all up for the next time I use them.
All right. The next one. In this case, the defendant is
Is that
accused.
10, Judge?
That was
That is 10.
Okay.
In this case, the defendant is accused in an indictment.
No objection.
That will be 11. Murder is the unlawful killing of a human being.
No objection.
That will be 12. Malice aforethought means the intentional doing of a wrongful act.
No objection.
No objection.
What number would that be?
13.
13? Okay. Express malice is that deliberate intention.
No objection.
No objection.
14. Murder of the first degree is murder.
No objection.
No objection.
That'll be 15. And now we're into the Byford series. The law does not undertake to measure in units of time.
No objection.
No objection.
That'll be 16. Although your verdict must be unanimous as to the charge.
No
No
objection.
17. The next one is you are instructed if you find the state has established.
No objection.
No objection.
That will be 18. All murder which is not murder of the first degree is murder of the second degree.
No objection.
No objection. Oh, sorry. No objection.
Is that 19?
That was 18.
18?
18.
Thank you.
No, that last one was 18.
Yep. Okay.
Also, murder, which is not first.
His second is 18.
No.
It's 19, I'm sorry.
Is 19.
All murder is 19. We on the
Great.
same page?
The killing of another person in self-defense.
So we're getting these?
Yes.
Okay. I will rely on my previous objection.
Of course, but you agree that's what we've agreed to essentially.
Yes.
All right, so that'll be 20.
These are correct statements.
These are all run-in. A bare fear of death, another run-in instruction will be given as 21.
Yes.
An honest but unreasonable belief in the necessity for self-defense, that will be given as 22. The right to self-defense is not available to an original aggressor, will be given as 23. Actual danger is not necessary to justify killing in self-defense, will be given as 24. The killing is justified even if developed afterwards, the person killing was mistaken, will be 25. If evidence of self-defense is present, state must prove beyond reasonable doubt the defendant did not act in self-defense, will be given as 26. If a person kills another in self-defense, it must appear, will be given as 27. And then we're out of the run-in series.
Okay.
Okay. Then we're into the deadly weapon enhancement. You're instructed if you find defendant guilty of first or second degree murder, you must also determine whether a deadly weapon was used.
No objection.
No good. 28.
That'll be 28. Deadly weapon means
No objection.
29. That's 29. State is not required to have recovered the deadly weapon.
No objection.
That will be given as 30. If more than one person commits a crime,
No objection.
that'll be given as 31. To constitute the crime charged,
No objection.
that'll be given as 32. Defendant is presumed innocent.
Can we slow down just a little bit? You're faster than my fingers.
I just wanted to make sure we took out this one word. Okay, no objection, as revised. 33.
That'll be given as 33.
Yes, sir.
You guys have met and conferred about that and come up with this.
Yes, we took out the word material pursuant to the Burnside case.
That's
Okay,
correct.
perfect. You're here to determine if defendant is guilty.
This was an instruction that the defense offered a revised version and the state agreed, so.
So this will be given as 34 as
Thank
modified. The evidence you are to consider in this case,
No objection?
that'll be given as 36.
No, 35.
35.
35, Judge.
Thank you. That'll be 35. It is a constitutional right of the defendant, he may not be compelled to testify.
No objection?
And to be clear, you are requesting that?
Yes.
Okay, that'll be given as 36. You heard evidence regarding drug trafficking, federal convictions, and gang affiliation. This is our Tavares instruction, correct?
Correct.
Okay, that one will be given as 37.
And Your Honor, just for the record, similarly to some of the other ones, Ms. Panduck asked us to revise it a little bit, and we agreed to her revisions.
Okay, perfect. Thank you for putting that on the record. The next one is a proffer agreement is a contractual agreement between a sovereign and a defendant that obligates a sovereign and the defendant to its terms.
Your Honor, we discussed this. My concern was with the word sovereign, that the jury may not understand that. And so there was some discussion about changing that word to jurisdiction or government. But
How about a specific government entity? Is that better, or? But, I mean,
I don't know if the court has a similar concern.
Sovereign always reminds me of a sovereign citizen.
I know.
You can use whatever term, like a specific government entity.
Okay,
I think that would be better.
all right. So if you guys want to replace the word sovereign with specific government entity, it does. So it would read: a proffer agreement is a contractual agreement between a specific government and governmental entity and a defendant that obligates that government entity and that defendant to its terms, wherein both sides of the contract expect the benefit in exchange for entering into the contract. It does not bind any other government entity. In this case, you have heard that the defendant entered through. Do you want to spell out count through?
Yes, it should be spelled.
Instead of like a drive-through at McDonald's, like the actual way the word is spelled. Yes. All right. Through counsel into an agreement with the United States government, the state of Nevada is not bound by that agreement. So there's no objection to that with the replacement of the word sovereign.
Yes,
Okay.
that is.
I'll give that one as 38. A statement need not made by the defendant himself to be considered his own statement.
No objection.
That will be 39. Statements defendant made during a police interview. That is,
Okay.
This is going to be 40. We have discussed it, your prior objections stand, but ultimately your request for instructions on voluntariness are acknowledged and given.
Thank you.
All right, and then the next one,
Just for the record, the state does.
and the state
objects
objects
to
to the
the
giving
vote.
of them, but got their wording.
Correct.
Okay. So that was given as 40. And then the next one is in the same vein. In making a decision about the voluntariness of a confession or admission, this will be given as 41 pursuant to our previous argument. The next one is where independent evidence establishes.
Let me read this more carefully.
This is the corpus one. We called it corpus, but I disagree. It's really corpus.
The corroboration.
Corroboration instruction, let's call it that.
Our objection stands.
Okay, but you agree that's what we decided
what
on?
the court decided on.
Okay, so that will be given as 42. Previous objections are noted. The next one, wherever there is slight evidence that a conspiracy existed.
Okay, I usually put this one earlier, but let's just keep it where it is. Okay, 40, no objection.
That'll be 43. In deciding the facts, you may have to decide which testimony to believe.
No objection.
This will be given as instruction 44. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness.
No objection.
That will be given as 45.
Okay, hold on.
Although you are to consider only the evidence in reaching the verdict, you must bring your common sense.
No objection.
That will be given as 46. During this trial, you received certain audio recordings.
No
And
objection.
it explains that the audio recordings are the evidence as opposed to the transcriptions, which may contain errors.
No objection.
That'll be 47. The next one is you may not discuss punishment.
This is one that I asked for alternative language to be used, and the state agreed.
Okay, so as modified, it will be given as 48. When you retire, you must select a foreperson.
No objection.
That will be 49. In your deliberation, you desire to be further informed on any point of law.
Objection.
This is the playback, so
Hold on. So 50, no objection. And 51.
you need the instruction in there that the jury is not to test any theory of the case, etc.
Yeah, we should.
Oh, yeah, I always forget that now. There's a court rule for that. So maybe we should add that before 51.
Okay, let me pull up.
Or make it 51.
Let me pull up the ones that I've used for previous cases.
Wait a minute. Hold on.
Oh, okay. I'm realizing at this point that we're missing ones.
I feel like we're missing one too.
We are, and she's grabbing it. It's the one where they're not supposed to do any research or look on social media and all the other stuff that the court requires us to do.
And I haven't finished with going through them, but I realized at that point that we were missing that one. The Bowman instruction.
Which is going to be 51 the whole. I'll add it as a change. Page break. I think the clerk typed that one for me in our last trial. Let's see, Aubrey. I have to bring up that.
Please don't mention that right now.
Using that one.
Those instructions work great.
Yeah, where is that one?
Ask him. Hey, do you guys have the credibility instruction in there?
Yeah.
Yeah, it's the lengthy one. It's not the short one.
Alright, so the
Okay,
Bowman
we wanted the
instruction
short
needs to
one,
be
yeah.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, listen to any news or media accounts or commentary on the case. Do any research such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's
instruction is this?
it's the instruction from.
Which number though?
I'm
It will
going
be
to have to
51.
add it in. We don't have it. It's from Bowman versus State. In 2016, the Nevada Supreme Court indicated it was. First of all, that I had to read the admonition that I do every single time we leave the
Should
room.
we state it? I just noticed a
Absolutely.
missing
Yes.
instruction that I thought was in there.
Okay, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research, such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own.
No objection.
Okay.
And what number, that's,
We could just make it 51.
And then I'm emailing it to you, Mr. DiGiacomo.
Oh, I just, the beginning of the one we used last time was slightly different, so it's during deliberations. Just review that, and I have it in here already.
During deliberations, other than deliberating with each other in the deliberation room,
Deliberating
with each other in the
deliberation
room,
comma.
jurors are not to, colon,
Or not to. Okay.
all the things. Okay, so that'll be 51? Is that the idea?
and then the
That would
last
make
one will be
sense.
52?
Yes, so we'll put the Bowman instruction as 51, and then 52 will be, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict. And that would be 52.
There was an instruction that was omitted from these, so the state presented a different credibility instruction.
Okay.
But I thought that this one, which is a stock instruction, would be included, and I see now that it is not. It's the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. That is a stock instruction.
Any objection to using that instruction as opposed to the one that you've included? It's
At 44, if you want to replace that in 44, I have no objection to
Okay.
that.
And I also don't mind using both of them.
Well, I mean,
We
there's
need one.
duplicative. We need one. So if you want to
if
use,
that's your request for that instruction, Ms. Pandak, that's the one we'll use.
Thank you.
If you want to just give that wording to Mr. DiGiacomo. Or- He has
I
to
actually
type it
can
up.
get it
Can you
because
get it?
what
It's the one
happens?
he's used
What
in
happens
every,
is the court.
he's used that in every other trial and objected to this one, but today he decided to switch it up on me, so
Yes,
I'm understanding. You're fine. Okay.
It's just because I stole these instructions from ones you made me do last time, so I'm like, I'm not even going to fight this time. Ability of a witness should be determined by his manner upon the stand. His
Okay, so while he's working on that, the state has proposed the verdict instructions, so the verdict form, so I assume they have no objection to it. Ms. Pandak, any objection to the form of verdict?
Mr. Samtig requested that not guilty be listed first. I told Mr. Druckenmiller he did not agree.
We object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step-down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step-down instruction to a step-up instruction, and so that's generally why I don't do it in these cases. But all right, so other than that objection, the crimes included are the crimes you're requesting to be included.
Yes, we did not request a voluntary manslaughter to be
Okay. That's on record. All right, Mr. DiGiacomo, then do you have everything added to yours?
I'm still typing that, Judge.
Okay, perfect.
But as soon as I do, I will send it to you. Okay, I think save as, final numbered, and I can send this around to everybody.
Okay, sounds good. Anything else we need to address while we have this time before we do closings on Monday?
We'll be at 9 o'clock as opposed to 9:30?
We hope.
I think the idea is we're having everyone get here at 9, but if we ultimately start a little later, that may be what ends up happening. But I also have to read instructions, which takes about, with 52 instructions, we're thinking maybe 20 to 30 minutes. So I don't think that we would be starting actual argument until about 9:30, at least. Mr. Sam?
I'm sorry, Judge. I don't remember in this department. Do you give each one of them a copy of the instructions to follow along with?
So what I do is I read the instructions to them and tell them to write down the ones that they want, and then we give 6 copies in the back.
I see. All right.
Okay.
Thank you.
Anything else?
Nothing from the state, Your Honor.
Nothing from defense?
No, Your Honor.
All right, we'll be in recess. We'll see everyone back on Monday for closing arguments. Thank you, everyone. Have a good weekend.
You can have this back.
Well, that was interesting. Thoughts and opinions and thoughts. Oh my gosh. So I didn't even think this was going to be televised, and it was. I was like, okay, well, I guess we get to hear. And we were actually we were a lot late, about 7 minutes into it when they started. So I also want to talk about the lawyer addresses Suge Knight. I don't know if you guys saw this, but there was an interview that was dropped yesterday, and I was like, we gotta talk about this because he addresses the rumor that he offered Suge Knight $1 million. He's like, why would I give him $1 million when I'm working pro bono? He said, why would I give him $1 million while I'm working? So we go get into that. I want us to review the arguments as well. I am going to drop the link as well. But before I drop the link, let's get into this. And then we go talk about some of these jury questions as well, since we're here. Put a 1 in the chat if you've seen this one already. Put a 2 in the chat if you have not. 1 in the chat if you've seen this. Law and Crime and Court TV dropped this this morning. So I'm kind of curious. 1 in the chat if you've seen it. 2 in the chat if you have not. This is a very interesting interview, I might say. Okay. Yeah. Let me see. 2, you have not seen it. Okay. 1 if you've seen it. See, I don't think a lot of people have seen this. Y'all got to watch this. Let's see if we can do it this way. I'm going to speed it up a little bit just for the sake of time. So he does this interview. Listen to what he says, okay?
How are you?
All right.
Oh, this is so bad.
Okay, so we're way ahead of schedule. Is this what you expected?
We just didn't want to do it in front of you guys. So we got into the first box and we said we got to get out. No, we are ahead of schedule, but not really. I mean, if you really looked at the facts in the case and the details that were in it was pretty clear that it was going to be a very short case.
How do you feel about the state, the witnesses that they've brought forward so far, and how you've been questioning them?
How I've been questioning them? I don't know.
How would you rate your performance?
Out of 10, maybe a 2, 2.5.
Why do you think that?
Because there's always room for improvement. I don't know. That's a horrible question. I can't give you an answer to that. I always think I could do better. Let's put it that way.
Has Mr. Davis decided whether he'll testify?
He was advised today of the court as to his right to testify, and so the court's given him time to think about it. And so he has until the time that we rest our case in chief to make that decision.
Has he told you if he wanted to?
And at this particular point, I think that's a question I can't answer because it's attorney-client privilege. But as of right now, he's contemplating that decision. So,
if he chooses not to testify, do you think that could be a problem because what the jury will be left with is his words confessing to this multiple times and there's nothing from his own mouth to rebut that?
Confessing, boasting, promoting a book. I mean, the clips you heard today was him promoting his book and not being comfortable or familiar with the facts that was asked of him. So, I mean, I don't know. You say confession, you say potato, say potato. It's like, once again, If you and I were dating, I'm not quite clear if I came home late with, lipstick on my collar, that I call it the truth, and you'd be like, no, you're lying to me. So there's a lot of this stuff that I think on some level, what we say and what we do are two completely different things. And so in this particular,
He said, if you and I are dating and you come home with lipstick and if I come home with lipstick in the collar, what would you take that as? I'd be like, you ain't coming home. You're not coming home. What do you guys think? I mean, I don't know. Yeah. Taylor says he seems annoyed. Shout out to everybody. And Jew, hey, shout out to my boo, my wonderful supporter Jew over here who gave a very generous super chat. Y'all send some positive vibes to Jew, who is we got to get her spirits up. Jew, you got to tell us how everything goes. Please, and thank you again for that very generous super chat. Thank you, love. I appreciate you. But yes, sending you love and support. And shout out to everybody that's gifted jewels. Thank you guys. I promise I'll shout you guys out here in a minute. Just give me a minute. I want us to get ahead of time.
particular case, it's not like, how much you love me, it's show me that you love me. And in this case, they haven't shown anything to indicate that. You hear a lot of words, but you don't hear anything that says, here's the evidence, here's the thing.
How has he felt throughout this whole trial? I remember last Monday you said he got one of the first day jitters, but we're not almost 2 weeks in.
I think he's in good spirits. He's been paying attention, and every once in a while he'll have a note or two of something that he's observed. So I think he's been doing the right thing.
When he addressed the court a couple of times, he sounds frustrated.
He is frustrated. He's frustrated more about the fact that there's been addresses given in the media about his family, which are typical things that you sort of redact and keep away. And even though it's 30 years ago, his family still lives in those addresses. So as a result, there's always been a lot of concern of people either going over to the addresses and doing things. So he was always concerned about that.
Do you think his previous attorneys during the proffer and even during the Vlad TV interviews and other paid interviews failed him?
That's a tough question. So I took this on pro bono, right? Which means I don't have any other cases. So attorneys will manage cases as they go along, and as cases are starting to get closer to the trial, they'll prepare. And the problem is, though, when you're doing it pro bono, you're not getting paid, which means your office is not getting paid, which means how do you keep the lights on in the office if you're doing a 5 to 6 week trial like what the state had said. We've been blessed enough at our firm, since we do a boutique injury firm, that we've been very successful at it, and I have 2 amazing partners. And so as a result, I can, do this frolic, go out there and try this case without having to worry about paying the bills for 5 or 6 weeks or whatever it would take.
But would you have let him do the paid interviews? Would you let him have done the proffer previously?
Oh, you mean mean those guys?
Yeah.
Oh, no. There's some other things going on underfoot there. I think those other attorneys had motive to push him and to cajole him and to get him in position to say those words, whether it was for financial reasons. Mr. Higgins was not a very good person, from what I understand. So there's all kinds of reasons as to why they would sort of push Keefe in a position to
Is somebody going to testify to that on staff?
No, I'm not going to do that. No one's going to testify to that because that's sort of outside of the scope of what we're trying to do here. And that is, does the state have enough evidence, like real factual evidence, to prove that Duane Davis was even in Las Vegas? And the answer is that right now is actually.
Michael, you've heard the phrase.
What witnesses do you plan on calling, and what's the goal?
So tomorrow's just to kind of clean up the state's case. So there's a couple of things that they did not do. They didn't call Detective Long, who's the second detective after Detective Becker. Obviously, they're not going to call it Detective Mall. He is nowhere to, he's not coming forward. And so we're also calling 2 Metropolitan police officers that were present in 1996 to clean up another issue. And then outside of that, we're done.
Michael, you've heard the phrase, man's word is his bond. Should a man's own word be enough to convict him?
So there was a movie called Jerry Maguire, and in that movie there's a guy who shakes the hand of Jerry Maguire and says, "My word is my bond," and then he screws him right after. So in essence, we live in a world today that if you don't write it down on a piece of paper and attests something to be true and correct to the best of your knowledge, then it's just the word.
It's not exactly what he did with his book, and then he testified to veracity of it multiple times in the interviews.
I don't think he did. You might want to double check that.
So are you saying that his word isn't worth the paper it's written on, even now today?
What?
Are you saying that his word is not worth the paper that it's written on, even today?
I think anyone's word is not worth the paper that it's written on until such time as it's proven to be true.
The prosecution witness this afternoon was talking about your client, in his opinion, mouthing words at Reggie Wright Jr. Do you know what your client was doing at that point?
Look at this.
I think he just hates him.
Do you know what he was saying?
Don't know for sure, but whatever it is, it's not what I think the media thinks it is.
Did he tell you?
Was I muted when I said, oh, I'm so sorry, guys. I got to get used to it. So what I was saying was, what did I say? I said that, that Higgins, right? So he said, he was talking about Higgins. He said that he wasn't somebody very good. And essentially, whatever was going on, it was to push him for money, right? They were trying to make money off of the situation. Sorry, y'all, I'm getting used to it. So I apologize. I was muted.
His feelings about Reggie Wright Jr.?
I have my own feelings about Reggie Wright Jr. and I think a lot of people do. And in this particular regard, I think no one can. If you know the story of Reggie Wright Jr., you can't sit there and be happy that he's there. You would think in your mind that this guy is not a nice person.
There's been a public statement from Suge Knight saying that your team had offered him $1 million. Do you want to respond to that?
I'm doing this pro bono, man. I don't know what to tell you. Sure, I threw my own money into it as well. Like, no. He's declined interviews with me. He did have an interview with the state. He did sit down with him and talk with him for 2.5 hours. But when the defense came along and said, hey, we'd like to sit down with you and find out from you some more information, he told me to go pound sand. So the answer is, I don't know what it's about.
So Suge Knight did speak with the state for 2.5 hours?
He spoke with Detective Mogg. Maybe investigator Mogg at that point, but they did, yes.
Do you know what year that was? A while ago, right? Do you know when?
I don't know, I can't remember for sure.
Do you know what he told Mogg?
Stuff.
Can you tell us what he told Mogg?
I mean, well, nothing that came out during the course of the trial because it's nothing that the state decided to show. Now, whether or not, like I said, this is all stuff that I'm hoping the jury's not understanding this, but at the end of the day, it's the stuff that's in court is really the stuff that we have.
He basically called Suge a snitch. Did you guys hear that? Like, inadvertently, he just called him a snitch. How are you going to meet with Detective Mogg for 2.5 hours? And then you're talking about the defense paid me or wanted to pay me $1 million when this man and his firm is taking the case pro bono. Where the hell is the $1 million going to come from? Like, literally. See, TMZ, people keep giving Suge Knight the mic for what exactly? If it's not just to muddy the water, and I think, honestly, I think that if they ever get to the truth of this case, it's not going to look pretty for Suge. And I'm not saying that he had something to do with the murder of his friend or artist. I don't know, man. Something ain't right about that situation. And I love that he said how, I have my own feelings about Reggie Wright.
They chose not to provide Suge Knight.
Do you expect a long deliberation?
No, I don't.
Suge Knight was on the witness list. Were you surprised they hadn't brought him in?
They put 200 people on that list. I was waiting for Mayor Goodman to show up. I was waiting for David Chesnow to show up because they put him on the list. So in terms of the surprise, I don't know what to tell you. I was surprised that the list was 200 people long and that it included people like Mayor Goodman and David Chesnow. What's the point of that?
That list was a fraud. They never intended to call these people as witnesses. That's how I see it now. I thought about this last night. I said, y'all just name drop these people. And of course, we're over here thinking, oh my God, they're going to become. No. I think it was just a show and tell. That's all. Just because it could put them on the list doesn't mean that they're going to call everybody, right?
Grand jury testimony seemed to focus on Nick's book quite a bit, and we didn't really hear too many portions of that being read into the record. Why do you think that is?
It's because it's... I mean, at the end of the day, they didn't read it because there's nothing in it that is corroborated. So in terms of the book itself, the jury will have a copy of it. They can read it for themselves.
Can you confirm for the reporters that are asking, is it Keefe Keefe, what's the right name? And
Say it.
spelling.
That's a point that I can't get into right now.
As long as we'll have to issue corrections for the spelling of his name.
Okay, as long as no, just don't throw that out there.
And Michael,
Block
one
that
final
out.
question. What's your favorite movie?
Nice man.
It's The Notebook. See what I just did there?
The Notebook. See, he kind of, sorry, not The Godfather. He said The Notebook. So that one, okay, all right. Shout out to Mr. Michael, the attorney. Who knows? Maybe once this is over, we might invite him to hit the link and see if he'll talk to us little people over here. He might be a little busy and whatnot, but shout out to him. You said a hit list. Why can't he get into that? It's such a simple thing because of the name. Because I think that the name, verifying the name would be like getting into the semantics of why his name is spelled the way that it is in the book, if that makes sense. All right. Now, I know, hold up. Let me see if I can drop this link, if I can figure it out finally. Here it is. Let's see. Shout out to everybody. Oh, okay. Start collab. Let's do that. All right. Okay. I'm going to drop the link. Now, here we go. So this is Streamlabs. I did test it out yesterday, and it was pretty basic. It's kind of like StreamYard in that, you just have to make sure everything's connected and whatnot. I am going to put a little marker before anybody comes up here because we got to make sure that we don't want any OnlyFans, we don't want any of that or any porn bombing or anything like that or prom bombing. Yeah, he can't get into any of that because he's still in trial. So there's a link if anybody wants to join. But let me know what you guys think so far. Now we're going to get into the opening statements and whatnot. Let me shout out also, let's see. I'm trying to figure out how to, first of all, thank you so much, James, for the super chat. A weasel walked into a bar. The bartender says, wow, I've never served a weasel before. What can I get you, Pops? Goes the weasel. Shout out to James. That was funny. Dorian Angel, thank you so much for the $5 super chat from earlier. Sending you love. Love to all Friday. Thank you. Shout out to, so I get notifications here of new subscribers too. Shout out to the new subscribers. Shout out to everybody. Shout out to everybody that's been getting I wish I could see the jewels here too. I don't see them, y'all. Forgive me. But if you've sent a jewel, thank you. Don't get mad at me if I didn't shout you out. I said, I got to go to Pets at home for my rabbit corn. I did drop the link for anybody. I don't know if Ty wanted to come up. I think he was planning to. Hopefully he's not having issues with it. He said, I told y'all Matthew McConaughey would play him in a movie of this, but now I think he'll play himself. Something. I got to figure out where that dingy noise is coming from. I haven't figured it out yet. And I muted it all. Now, hold up. Let me see if... Can I check here? Thank you. Is it Baby Mash? Thank you so much for the gifts. The First Lady, thank you again for the gifts. Nebby, shout out to Nebby. SJ, Pika, thank you guys for the jewels and gifts. Thank you. You said, I want to hear Vicky talk about this. Well, Vicky is busy, but she's more than welcome to hit the link if she can, respectfully. The lady's a busy lady. What we can review the opening statements here, but I don't know if anybody was going to come up. If they come up, we could stop it and talk a little bit about everything. I think this is important too, and I thought about this yesterday, and shout out to Ty who also said it yesterday, but I wrote it in my notes about the opening statements because where we're at right now, closing arguments Monday, now kind of going back to the beginning as to how they started. Now, pretty basic how the state started. I mean, I didn't think it was like, I felt like it was just a review of the same things we've heard again. And the state's opening statement lasts about so we're rewatching this. It's about I want to say, 20 minutes? And then we get into the 25. Then we get into the nope. Oh, okay. It's the whole thing. All right. So let's review this. Let me know your guys' thoughts in the comments. I'll stop it and give some commentary because now we're like in a different, I would say, area of the situation.
Good morning. On September 7th, 1996, Tupac Shakur came to Las Vegas to attend a Mike Tyson fight. After the fight, Tupac, along with Suge Knight, Trayvon Lane, and other people that were with that group, ran into a person named Orlando Anderson. And Orlando Anderson is a defendant's nephew. And when they encountered Orlando Anderson sitting by himself, they attacked him. That attack was captured on video. Then, a few hours later, Tupac Shakur and Suge Knight drive down Flamingo Road to Club 662, where Tupac is scheduled to perform a concert. Then 2.5 hours later, after Tupac and Suge engaged in the beating of Orlando Anderson, they are gunned down. Tupac is gunned down in a drive-by shooting from a white Cadillac in an act of revenge. During those 2.5 hours, you will learn that the defendant was escalating and planning the retribution for the beating of his beloved nephew. Now, let's be clear. Duane Davis did not kill the defendant. But what he did do was plan the retaliation for the beating of his nephew. You will learn that Duane Davis got the gun. You will learn that he got into a white Cadillac. You will learn when the opportunity presented itself for retribution, Duane Davis made sure that the shooters were armed and ready to execute their revenge.
He said, you will learn, you will learn. You will learn, you will learn. Now, what I find so interesting about the state's case, right? It's that it's a series of recordings, and we're supposed to, at least the jury is supposed to decipher from that. You will learn from the state's recordings. That's really what it is, right? And the proffers, right? Nothing else. No witnesses. That's it. That's all. Just his own words, right? That have changed throughout the time. Fair to say.
And remarkably, you will learn that from Duane Davis himself. But to understand what happened on September 7th, 1996, on the streets of Las Vegas, we need to go about 275 miles west to the city of Compton, California. What you'll learn is that Compton is about 10 square miles. But in the mid-1990s, those 10 square miles were occupied by over 30 gangs claiming its territory. And according to this case, there are two gangs, Mob Piru and the Southside Compton groups. Let's talk a little bit about the Mob Piru. The Mob Piru is a group that associated with the color red. And you'll hear that Suge Knight, the person who was driving Tupac Shakur that night, grew up in the neighborhood of Mob Piru. But by the mid-1990s, he had become a very successful CEO of the record label Death Row Records. But despite, maybe because where he came from, you'll hear that Suge Knight continued to employ Mob Piru gang members as part of Death Row. They would act as unofficial security, and other times they would engage in, let's call them blood rights, on behalf of Suge Knight. But Death Row in the mid-1990s was one of the most successful record labels around. They had artists such as Snoop Dogg, Dr. Dre, and of course, Tupac Shakur. And in 1996, Tupac Shakur was maybe the largest and biggest, most successful rapper around. He had just released All Eyes on Me, a double album that was met with huge success. Additionally, Tupac Shakur was a movie star, having appeared in a number of movies in critically acclaimed roles. He has, at times, been referred to as an icon. But for the purposes of this case, what you need to know is that Tupac Shakur was not a gangster. He was a hip-hop artist associated with the Mob Piru. Now, the other gang that's important to note here is the Southside Compton Crips. And when it comes to Southside, Duane Keefe D Davis was the leader of the Burris Street faction of the Southside Compton Crips. And while Suge Knight rose to prominence in his neighborhood due to the money that he was bringing in through the music industry, Duane Davis rose to prominence in his neighborhood because he was a...
Did they prove that? Quick question. Did they prove that he was the leader? Did they prove that through his own statements? Because I'm going back to what they use, and I don't remember him saying that he was the leader, right? Or he was the shot caller. I mean, if you're going to use the book, you could say the book says it. Okay. But did the state prove that this is his affiliation and this is who he was? I felt like I didn't really hear it from the state. Hell, even Dirt Rock didn't really say it like that either, but I don't know.
Very successful, large-scale drug trafficker. And you will learn that that is how one moves up in the world of gangs, by bringing in money to the neighborhood. The other thing you'll learn is that Orlando Baby Wayne Anderson was his nephew, and also a highly respected member of the Southside Conference. Now, as part of this case, you're going to hear another name, Eric Zip Martin. Now, Eric Zip Martin is not a member of the Southside Conference. In fact, he's based out of New York. He's involved in the drug trade and knows Duane Davis as a result of both their involvements in the drug trade. Duane Davis from the West Coast, Eric Zip Martin from the East Coast. And one of the connections that Duane Davis gets through his association with Zip Martin is with Sean Puffy Combs, who was then the CEO of Bad Boy Entertainment. Sean Combs wanted some security when he came out to the West Coast. He was worried about Mob Piru. He was worried about the members of Death Row Records. And so Duane Keefe D Davis agreed to be around to act as unofficial security for Sean Combs and his artists when they came out west. In order specifically to ensure there are no problems with Mob Pyro and Death Row Records. And this was a rivalry between Mob Pyro and Southside Compton Crips, and escalated it. And those tensions boiled over in the Lakewood Mall in the summer of 1996. There, you'll hear that Trayvon Lane, a member of the Mob Pyro, associated with Death Row Records, was there with other members of Mob Pyro in order to do some shopping. Lakewood Mall was a mall nearby Compton. You'll also hear that Baby Wayne Anderson, Orlando Anderson, the defendant's nephew, was there. Now, Trayvon Lane that day was wearing a chain with a Death Row medallion. And there was a fight that occurs between the Mob Pyro group and the Southside Compton Crips. And at one point, that chain is pulled off Trayvon Lane's neck. Now, what happened to that chain is an issue of much dispute.
Listen, I know some people are colorblind, but like, is the jury colorblind that you have to put one is red and one is blue? I don't know who designed the clips. I was like, who did all this? They designed the whole clip. They even put the Death Row Record Bad Boys on that. Y'all see the design in this? Are you paying attention to the design in this? They got Death Row Records right here. And then Bad Boys, the logo is up there too. I said, I mean, I guess you do need something like this because there might be jurors out there that don't know. But yeah, I don't know. I don't know. You said, oh my gosh. Yeah, with the Colombians. I don't know. I mean, all right. So there was a chain right here, which, by the way, the Lakewood Mall. Where's the police reports on the Lakewood Mall? Where's the reports on this shit? See, and I even forgot. Where's the reports? Anything? No, Ty, are you having a hard time getting on? You said, I don't know how to use this panel thingy. Okay, are you able to click it? Let me know. If not, I could probably pull StreamYard from here too, but yeah, I can do that. I could pull StreamYard as well. But let me know. If you can't click it, let me know. I think that's a notification from a new sub. Thank you, baby cakes. Thank you for the super chat. And I will shout some folks out here in a minute. Ty, let me know if you can get up. If not, I'll send you a link for StreamYard. Anyways, so again, this right here, I feel gaslit because I'm like, what happened with the Lakewood? Let's see how he tells it, okay? But let's go.
But the act of disrespect of pulling the Death Row chain and the brawl that occurs further escalates this heated rivalry. And what you'll learn is that these two men, Trayvon Lane and Orlando Baby Lane Anderson, they encounter each other again, this time in Las Vegas. So that brings us back up to September 7th, 1996, here in Las Vegas. Again, Mike Tyson is fighting Bruce Sullivan. He disposes of him in less than in a round. Doesn't take a full round. And then after the fight, Tupac Shakur, Suge Knight, and the people that are here with, they leave. And among his group is Trayvon Lane. And that is why this fight occurs. Trayvon Lane and the Death Row group sees Orlando Anderson standing by himself, and they decide to attack him in retribution for what happened at the Lakewood Mall. You'll see Orlando Anderson's on the bottom of that group. You see security coming, trying to break this up. And then you'll see Tupac Shakur, Suge Knight, Trayvon Lane, and that group exit the MGM Grand. Now, Orlando Anderson was by himself because when Duane Davis purchased the tickets for the Bruce Sullivan fight, he got them through a scalper. So everybody that came with Duane Davis were seated separately throughout the fight. And so Orlando Anderson was at that time by himself. You'll see that Mr. Shakur, Mr. Knight, and his group leave the MGM Grand. And you'll see that Orlando Anderson, after being held by security, is questioned for a bit, asked if he wants to press charges. He decides he doesn't want to participate in any type of prosecution, and that he doesn't need medical attention. Duane Davis hears about this meeting, and what you will hear is that in his world, there is no question that a response is required.
Okay.
And you will hear from Duane Davis what happens next. Because...
Hold up. Ty, are you here? Oh, I see you here twice. Ty, are you here? Because it says I have you here, and it is a blank screen. Let me see. Ty, are you here? Are you here? Let's see. For those... Hold up. Let me see if I can get him. Oh, okay. Hold up. I see... Give me 1 second. See if we can get you up on the very front. Give me 1 sec, guys. Let's see if we can get Ty up here. Ty. Hold up. Give me 1 sec. Are you there, Ty? Huh. I don't know if you're connected all the way because I could see your Wi-Fi, sir. Hold up. It says that you're here. Let's see. We'll see what Ty says in the chat. Hold up. Ty says, I'm here, but it's a blank screen. Yeah, I see nothing but blank on my end, but I see you. Hold up. Says I have 2 guests. I think you might have hit it twice. Hold up. See if we can figure this out real quick. Okay. Here's the fix. I'm checking the fix right now. All right, so okay. All right, if the properties window change device. Damn. Give me 1 sec, guys. Troubleshooting real quick, guys. Troubleshooting. Okay, now let me see, close you out here. All right, this is what I'm going to do, Ty. I'm going to send you a, okay. Okay. Cool. Let's see if we could try this real quick. I'm going to send you a link to see if I can have you on my StreamYard real quick. All right. See, can I invite somebody? Ty, I'm going to send it to you on your DM, okay? Give me 1 sec. All right, y'all. Sorry about that. Intermission, real quick. Just trying to get some stuff settled up. If not, I could just drop the link in the chat too. Hopefully we won't have any issues with the StreamYard as well, but we'll see, man. I heard a lot of people complain about StreamYard yesterday, honestly. So I don't know. I don't know why this thing is not working. I'm gonna have to test it. I thought, because we tried it yesterday and it worked fine. So maybe that's just on my end. Ty, go ahead and hit the StreamYard link. And we shouldn't have any issues. Hopefully it'll be okay. All right. While we wait for Ty to hit that, Ty, I put it in the chat if you can hit it. All right. Let me go ahead and keep going. I'm still trying to figure out what is making that dinging noise. That's going to drive me crazy, y'all. We'll figure it out. I'll figure it out at some point.
What happened over the next 2.5 hours is something Duane Davis would later describe himself in the secret 2008 interview from his attorney's office with the federal task force. And we'll talk about that interview and the circumstances surrounding that later. But we'll hear about what the next 2.5 hours was. So, what we learn is that Duane Davis is upset about the beating of his nephew. And frankly, that's not an unusual response. What's unusual is the next steps Duane Davis takes. Unusual for the normal person, maybe not unusual for in-gang culture. Duane Davis decides he is going to organize a retaliation, that this beating cannot go unanswered. Then he runs into a person named Zip Martin. Remember the Zip Martin that was a connection with Bad Boy Entertainment from New York? And Zip Martin tells him that he has a gun and that he can come help him out.
Hey, where he tells it right now. He tells it, hey, we're going to handle this shit or whatever.
Yeah, like, y'all lost the gun? Like, you know what I'm going to do? It was, they going to get 66 stupid.
Who said that?
Everybody.
Everybody.
Yeah, everybody. You know,
how do you know that this guy, does he tell you?
It was in the lobby, in the lobby.
Did you ask him? Do you have one, or just tells you, yeah,
yeah, I'm going to ask you to need help. I said, yeah, okay, cool.
I don't know what he gave you.
Yeah.
So later, Duane Davis organizes 2 vehicles to go over to the 662 Club. Before that, he gets the gun from Zip Martin. He goes out to his Mercedes-Benz, gets the gun from Zip Martin, and then after some time, he assembles 2 cars to go to 662 to violently confront Tupac Shakur and Suge Knight for the beating of his nephew. And you'll hear that Duane Davis wasn't initially in the white Cadillac. He goes into a van, and Orlando Baby Lane Anderson.
All right, let me figure out how to bring up Ty here. Ty, I'm bringing you up through my StreamYard. I'm muted on StreamYard right now, so hopefully you can hear me through another source. Hold up. Ty, can you hear me? Ty? Chat, y'all can hear me, right? Ty? Ty, can you hear me? Oh. Hey, Ty, can you hear me?
Yes. Can you hear me?
Yes. Okay. You hear me okay? Ooh.
I can hear you.
Okay, so hold up. I think this is the fix around.
I'm here.
Okay, cool. This is the fix around that we have so far for this, but we're gonna have to figure it. I have to figure it out at some point. Why you guys? All you got was a
Yeah, but
blank
that's
screen.
only because I am watching you on YouTube as well.
Are you? Okay. You can hear me. All right, everybody can hear me. Can you guys hear Ty as well? Oh, let me add Joe in here too. Joe, can you hear me? Ooh, I don't think they hear me. I don't think Joe hears me, but Ty hears me, but Joe doesn't. I'm trying to figure out the workaround.
Now I heard something, but do you hear me?
I hear you. Okay, you don't. Joe's like, I don't hear anything at all. I hear you, man. All right. Okay, let me see. Sorry, y'all. I mean, this is part of the. Yesterday it worked. I promise. Yesterday it worked. Today I don't know what's going on, and it sounds like it might have to do with something that I have to do behind the scenes to make sure that it works, that the connection works. Anyways, can you guys both hear me, right? Maybe. See if I unmute here. Can you guys hear me? Y'all hear me? Oh, they're both quiet. You said everybody's echoey but Rabbit. Yeah. Let me see. Hold up. I'm going to try to figure something out, guys. Oh.
If you can hear me, I cannot hear you.
You can't hear me. All right.
But I can see that Ty is muted.
Ty's muted. Ty, can you hear us? Okay. Taylor, I'll have to check out the stream. I promise. Y'all give me some time. I hear you, Rabbit, but Ty is echoey. What about the video? Was the video echoey too? Hold up. Let's see what's going on.
Wait, I heard that.
No, I know you hear me, Joe, but she doesn't hear us. I mean, I can't hear her.
Does she hear you? Oh.
Okay, let me check something real quick. Give me 1 second, okay?
This is a fucked up day.
No.
So what do you think?
Security. Go ahead and talk. I'm gonna mute myself real quick while I figure out the camera situation. Give me 1 second. Privacy and security. Okay, let's go to camera real quick. Nope.
So I just realized they can hear us on the stream, but we can't hear her specifically.
I can hear you guys.
Yeah, I figured that out.
The video was good? Okay.
Because I'm listening to it from
All right,
YouTube.
Do me a favor, guys.
I'm glad I found that out because I was about to say some stuff that get her kicked off YouTube.
Oh, potty mouth.
Y'all are funny. Okay, hold up. Let me do this real quick. Let me do this. Let me remove you guys for a minute, and I'm gonna try to figure out.
But the panel can still hear us, even though we can't hear her. So I guess you and I can just talk about it. What do you think?
Go ahead, keep talking.
Hold on, Joe. 1 second.
Sure.
Let's make sure. Yeah.
Hold on, guys.
I guess I'll just start with, since I know they can hear me, I'll just start by saying what I said in the beginning. This case sucks. And the prosecutor's cheating. But that's what they do.
Okay, she wants us to keep on talking. So what do you want to talk about? Let's go, Joe.
Well, me personally, like I said, I think the prosecutor is cheating with the self-defense instruction because the defense position, and remember, they didn't want that instruction. The defense position is that Keefe D wasn't there. The self-defense instruction doesn't work if he wasn't there. Now, I know that's the state's position, but that's why the state was demanding the self-defense instruction, to confuse the jury. This is the only time I have ever seen a DA demand a self-defense instruction. Any other time, they would have said he's not entitled to a any other drive-by shooting, the DA would have said this guy is not entitled to a self-defense instruction because he was the initial aggressor, and initial aggressors don't deserve self-defense instructions. This is the first time ever that I have ever seen a DA demand the self-defense instruction for an initial aggressor using a firearm. Sometimes you can punch somebody first and you can still get a self-defense instruction if you're not trying to beat the crap out of the guy, you're just trying to get somebody away from you. But you can't pull a firearm first and then claim self-defense. This goes against everything you're ever taught about self-defense. It was crazy, and it looks like the judge did tack that on. But that's just very confused.
The judge was also confused as to why he would add that.
Yeah, she wasn't on his side, but for some, I guess I'm trying to remember what was said back then. We had a lot of things said. A lot of it was just bullshit to begin with. But yeah, they were bullshitting with that one, and the instructions overall. And what was it? I'm still trying to remember that one thing that was said. But anyway, it'll come back to me later. Point is, overall, I still just from the beginning thought this case sucked because you might have heard in the beginning they're talking about the corpus delicti instruction. There's supposed to be evidence independent of one's own statements, even if that's a witness, even that could be a neutral witness, that could still count. Nobody put Keefe D at the scene. Nobody put him anywhere. Now, it's still going to go to a jury anyway, but nobody put him anywhere to be found. And the state knows that. They knew this was kind of weak. They still went through with it. But this is what they do. That's why I say prosecutors cheat. And let me see. Can I see the YouTube chat? If I go to the comments, let me give that a moment. It's not loading for you either. Okay, we're having all kinds of problems today. But anyway.
We'll iron it out.
But do you have a reaction so far? Are you convinced beyond a reasonable doubt this man is guilty?
I need to hear the instructions. Today's, as tedious as it may seem, the instructions of the jury is the most potent part of this whole thing because they cannot work outside of the instruction of the court. So today is game day. Today was game day. They both had to agree what the judge was going to tell the jury that they had jurisdiction over. I would like to hear it straight through, not line by line. So on Monday, I probably will find out with the rest of the world, what I feel, because I really couldn't really, I could listen, but I couldn't really get it because it was line by line. But that's I don't even think you didn't even argue self-defense in the case, so I'm so confused.
Yeah, then that's the point. If you're confused, that's the point. That's what the DA wants. The DA wants to confuse the issue because the self-defense doesn't make sense if he wasn't there. And that's not doing anything else but confusing the jury. It's just misleading them into believing that he was there. And granted, I think a lot of the people believe he was really there, but that's not how court works.
Right.
Court is about what was stated at the trial. That's what the lawyer was talking about in the interview. Court is about what. Yeah, the jury is even specifically instructed. The evidence comes from the witnesses, not anything else.
Joe,
even if you can see videos, photos, right? Somebody's got to speak and authenticate that. Somebody's got to tell the jury what this is for.
Listen.
So they didn't get anything independent of Keefe D's own statements that he was there.
Ty, Joe, can you guys try hitting the link again?
Do you think the jury? I know you're still trying to make up your mind, but why do you think the jury will do it?
I can't.
Can you try hitting the link again, Ty and Joe?
Okay, hold back. That's cool.
The instructions. I think she just dropped a link to the
try it again.
Streamlab.
Yes,
on the YouTube video in the chat. So let's try.
You want to try that again? All right.
Let's try that again.
Please, make sure you close everything out.
There.
Okay.
Leave here and then try it again.
Thank you, Joe. Go try it. All right. Hopefully that works. I had to do some workaround and yada yada yada. Y'all, he can't hear you guys because he's on the other side. I know they didn't hear me either, but hopefully they heard me. Well, Ty heard me. So let's see, because I did something to where, let's see. Okay. I see Ty. I see Joe. Hold up. I saw Joe for a minute. Come on. Okay, Joe's up here too. Hold up. Why are we struggling? I'm gonna have to figure this out. This is so sad. Damn it. Hold up. Can you guys see me okay? Yo, I mean, I don't even see them either. There's something else. Let's see. They still don't see me. I'm trying to get some. They cannot hear you and apparently cannot see the comments. They can't see anything. That's why I'm trying to figure it out. So make sure the device drop-down menu is set explicitly to, okay. Yes, that is the device drop-down menu. Hold up, y'all, hold up. One more. Let me figure out one more thing. I'm going to try over here. Hold up. Nada. It's like nothing. Nothing. Okay, I see Joe. Oh, and then he goes off. I don't know. It's like it kicks him out or something. Yeah, we're going to have to figure something out for this. Y'all going to have to give me a minute to figure it. I mean, I don't know if I'll be able to figure it out today, but we'll figure something out because I'm going to drop let me generate a new link, okay? Real quick. I'm going to generate a new link and see if this works. Okay, give me 1 sec. See if that works. It is super annoying. What are the dings? It's something that I got to figure out how to mute. Rabbit, I'm going to have to help. Yeah. Nah. Really, Flojo? Because I thought OBS was like a lot more harder. I'm trying to bring up the people and I can't figure it out. That's so weird that you say that because people said that it's the other way around. We will figure this out. Hold up, y'all. Here. Let's see. Okay, so let me do this because I'm like, I don't think I'm gonna be able to do this. And yesterday I tested it out and it worked perfectly. Flojo, can you hit the link? Can you see it? Because I'm kind of curious to know if you're able to see it. You can't see the new link either? Lord have mercy. Let me see if Flojo can see it. I don't know if you're able to hit it. I know you're a busy guy and everything. Yeah, where do you see Tinkle? I don't see Tinkle Tits. Oh. Well, Tinkle Tits is probably busy. You know, I don't want to be bothering. Flojo. See if you can. If you can't, that's okay, love. Let me see if I can, Oh, okay. Joe. It's like everything's connected and I hit and then he's gone. Okay. I don't know. It's like it kicks him out. I see you. I just need to show you. I don't know what's going on. Hold on. And then it goes away. Okay, wait. Let's go. It kicks him out. But if you want to hit the link, I'm just trying to see if it's kicking people out. See if you can hit the link on that and see, just accept everything. You might have to be on camera for like 5 seconds though. Sorry, y'all. Technical difficulties. We're gonna figure it out. We gotta figure this out. I'm determined to figure this out. So y'all bear with me, okay? Oh, hold up. I see Flojo. Hold up. Joe. Can y'all?
Can you hear me?
Yes, I can hear you. Can you guys see Joe? Y'all hear Flojo? So is it my end or is it? Did you have an issue logging in or what?
No, I mean, it took me to a web browser, and I was just able to just fill out my information and then click join.
It took you to a web browser, you said?
Yeah.
Hold on. Did you have to like accept everything or like did it like did you have any pushback or anything?
The first time it said there was an error connecting, but then I just retried it and it worked.
Okay, so guys, like Flojo can get in. Maybe it's something on your guys' end. Can you guys double check? I'm talking here. Let me see if I can bring, cause I got you up here. Hold up. Let me see if Oh my God, you said OBS is easier than Streamlabs. I know you lying. I know you.
The only thing with OBS though is that you can't like have a panel. That's what I'm trying to figure out. That's why I got StreamYard.
Oh yeah, because of the panel part.
Yep.
So, I mean, y'all, do you guys in the chat? Let me know. You guys hear Flojo good? Everybody hears Flo. Everybody hears you. They said that it's fine. So I wonder if it's a setting on the other side. Because I went back. I even went through because I have a MacBook. I went through the securities and you know how technical that.
The only thing that I could think of too is because I also have a Streamlabs account.
Mm-hmm.
I don't know if I'm signed in on it though.
Yeah.
So that could be a thing. I don't know.
Yeah, somebody said it's kind of like a Zoom account. Let me see if I can drop the link again and see. Okay, wait. I got somebody. See, First Liberties podcast, Joe tries to get in and then it completely kicks him out. Like he can't even bypass anything.
That's weird.
So I wonder if that's a setting there. Abraham, I don't know if you've tried it.
I'll send you a screenshot of what I see to your
Okay. Yeah, they have to give permissions to, but this is like StreamYard. It's like you have to give permission to your mic and your camera, everything. You don't have to show your face, but you know, you do have to give permission. Perfect. Okay, hold up. Let's see. Now Joe disappeared. He's sending a screenshot. Okay. Hold up. Abraham says, did you click join or join? Okay, Flojo, Abraham wants to know that when you joined. See
yeah, there's two buttons. There's one in green that says join with Streamlabs, and then there's just one that says join.
Abraham, just hit join. I don't know if Ty, if you want to try it again, it might be a setting. Is it? You're on your phone though, right?
I am, yeah.
Okay, y'all. We're gonna figure this out. Oh, who's here? Hold up. Somebody's here. Is already occupied. If you continue, Flojo will be unassigned. What? I can't add an. Okay, let me see if I can add a new source. 2. Let me see. Let's see. Oh, okay. So Flojo's up here. I don't know who Mickey is. Mickey, are you there? So for every person that's up here, you have to create a collaborative profile. It looks like Mickey hit the profile several times. Hold up. Mickey, I'm trying to get you up here. Can you hear me? Oh, Lord have mercy. Nope. I only see Flojo. Damn. Okay. Well, it's going to take us forever to troubleshoot. Can you see me okay, Flojo, or did you just drop? The Flojo just froze. Hold up. Here we go. Joe froze. Joe froze. Oh my gosh. Hold up. Okay, 1 second. I don't know who this Mickey person is. And there's a bunch of tags in there. I don't know. You said, hold up. But I'm joined. All right, all right. Okay. Let's see. Hey, everybody. Welcome, welcome, welcome. Shout out to everybody in the chat, guys. We're just trying to figure out some technical difficulties. That's all. I don't know. I'm going to have to figure this out. We're going to have to figure this out. Hold up. Mickey collab. Okay, that's Joe. Joe, are you there? Joe froze. All right. I'm gonna have to we'll figure this out. Okay, I'm keep saying that, but we'll figure that out. All right, guys, we have to continue and move on because we're gonna be here forever. I'm still in the chat, guys. We'll figure this out. Stay tuned. Yes, we need to figure it out. But the thing is that I am dead set to figure this out here because who is this? Hold up. What is this? I don't know who this is. Okay. Says I have 2 people up here and I don't see them. Okay, I'm back, says. All right. Let me see. I'm in the back in the chat now. Gotcha. You're back in the chat. Shout out to everybody. Y'all, I apologize. Who Cat's people? Shout out to Cat because apparently we got raided. Oh my goodness. Well, thank you. Thank you for the raid. Shout out to y'all. We're just learning, y'all. I apologize. We are technical difficulties. We'll figure it out. That's how we learn. Yeah, I don't know who this Mickey person is. Okay. We're going to move on. We're going to move on. I'll have to do another stream here where it's just panel and I'm not doing anything else but panel. So let me do that. Yesterday was great because there was no issues. So I wonder what happened today. Hold up.